Welcome back, everyone. Ready for another deep dive.
Absolutely excited to be here.
Today, we're tackling contracts. But with a twist, we're going beyond those simple two-party agreements. We're talking about those involving third parties.
Intriguing, right?
It is. Think of it like this. You order a pizza, right? But instead of it arriving at your doorstep, your roommate ends up with it. We're going to unravel how someone can benefit from, or even get stuck with obligations in a contract they weren't initially part of.
It's more common than you might think.
Exactly. So get ready to explore the ins and outs of assignments, delegations, even those intriguing third-party beneficiaries.
We'll break it all down, make it crystal clear.
And to guide us through these legal waters, we have a contract law expert joining us. Welcome.
Glad to be here, ready to dive in.
Let's do it. Let's start with assignments. Sounds straightforward enough, right?
Yeah.
Like handing someone a winning lottery ticket, you're transferring that right to win, to cash in, to someone else.
That's a great analogy. Imagine this. You're holding a contract, and that contract says you're getting paid a real golden ticket, right?
Absolutely.
Assignment is like passing that ticket on, legally transferring your right to that payment to a friend, for example. That friend steps into your shoes, essentially, and can now collect. They become what's known as the assignee, the one who will receive the benefit.
Okay, I'm following so far. So the assignee is the new beneficiary. But what about the person or company who was originally supposed to pay up? Are they off the hook?
Not at all. They're called the obligor, and they're still very much obligated.
So it's not just a casual, hey, you take this.
Yeah.
It actually gives the assignee real legal power.
Exactly. They can enforce that contract like they were the original party.
Even sue the obligor if needed.
You got it. But, and this is important, it's not a free-for-all. There are limitations. Let's say you're obligated to, I don't know, bake a cake for someone, and the contract specifies it has to be your recipe, your special touch.
Yeah.
You can't just assign that duty to your friend who's never even boiled water, right?
Right. It's not like baking a box cake where anyone can follow the instructions. Sometimes it takes a certain skill set.
Precisely. Plus, you might have clauses written into the contract itself, those anti-assignment clauses that say, nope, this right can't be transferred.
Like legal guardrails.
Yeah, you could think of it that way. Or even state and federal laws that restrict certain types of assignments. And sometimes, even if an assignment is technically possible, it can't happen if it drastically changes the game for whoever's left holding the bag of obligations.
Like if it significantly increases the burden on the person who still has to perform the duty.
Exactly. It's all about fairness and ensuring that the fundamental aspects of the agreement remain intact.
Okay, that makes sense. Now, you mentioned those anti-assignment clauses. Those sound like legal stop signs.
They are. They limit or completely block the transfer of rights in a contract. And this is where things get really interesting because the wording can make or break a case.
Okay, let's unpack that. How can a few words make such a difference?
It's all in the details. Let's say a contract states, assignment is void. That's a strong stance, making any attempt to transfer those rights completely useless, like saying, you absolutely can't hand off that lottery ticket.
So it's airtight.
Yeah, pretty much. But if the contract says something like, the right to assign is restricted, well, it leaves some wiggle room.
So it's a bit softer, open to interpretation.
Right. The act of assigning might be considered a breach of contract, but it might not automatically void the assignment itself. The outcome could go either way.
So one little word can make all the difference in how a court interprets a contract.
Absolutely.
Wow, it really shows why it's so important to have a keen eye for detail, or perhaps an expert legal mind review contracts.
Couldn't agree more. It's all about those nuances.
Delegations. It's like we're dividing and conquering, sharing responsibilities instead of just reaping the rewards.
Exactly. It's all about getting things done, sometimes with a little help from our friends.
It makes me think of home renovations. You hire a general contractor, right? But they're not the ones always installing the fancy tiles or, well, redoing the plumbing. They bring in specialists.
That's a great analogy.
So it's that delegation in action. Bringing in the subcontractors, the experts for specific tasks.
It is. Think of it this way. You've hired that general contractor, right? They're responsible for the whole kitchen, let's say.
Right, the grand vision.
Exactly. But they're not plumbing experts necessarily. So they delegate, they transfer that specific duty, installing the new sink, for example, to a subcontractor.
Okay, so it's like passing the baton, but instead of a relay race, it's more, you handle the pipes, I'll perfect the backsplash.
Yeah.
But legally speaking, how does this three-way dance work? Who's who in this scenario?
All right, so you've got the general contractor, right? They become the delegator. They're passing on a duty to the plumber in this case.
Right, the plumber who's the expert in all things pipes.
Exactly. And the plumber becomes the delegatee. And you, the homeowner, enjoying that fabulous new kitchen.
Living the dream.
Exactly. You're the obliged, the one benefiting from the duty being done right.
Got it. So I'm trusting the general contractor. They've brought in specialists. But what happens if that subcontractor, the delegatee, messes up? Who's on the hook?
Ah, that's where it gets really interesting. So even though the delegatee is performing the duty, the delegator, our general contractor, often remains liable.
Really? So even if I wasn't the one who directly hired the person who made the mistake?
It can happen that way unless, of course, the delegate explicitly agrees to take on that responsibility. It's kind of like, how should I put it? It's a bit like co-signing a loan, you know? The original party isn't entirely off the hook just because someone else is now involved.
Oh, that makes sense. So even though I hired the contractor, if the plumbing's a disaster, I might have a case against the subcontractor too.
It's possible, but it depends. There are times when you can't just delegate duties so easily. Remember those clauses we talked about earlier?
The anti-assignment ones.
Those are a bit different, but similar idea, right? So a contract might specifically forbid delegation for certain tasks. Or think about a personal service agreement, like, say, commissioning a famous artist for a portrait. You're choosing them for their unique style. They can't just delegate that to a student, right?
Right, I'm commissioning a masterpiece, not masterpiece in progress.
Yeah.
It's their name and skill set that are essential to the deal.
Exactly. And courts recognize that. There was a classic case, Sally Beauty v. Nexus Products, back in 1986. It involved an exclusive distribution agreement. One company gets acquired by a competitor and tries to just delegate its distribution rights.
Bold move.
Right. The court actually sided with Nexus, saying, nope, those original duties, those can't just be handed off. Too much potential for a conflict of interest there.
That makes sense. So even if a task seems like it could be delegated, you have to consider the context, the potential fallout, whether anyone's toes are getting stepped on, all those potential conflicts.
Precisely. It's about understanding the bigger picture, the relationships, what each party specifically brings to the table. It's not always as simple as just handing off a to-do list.
Third-party beneficiaries. Now we're talking about the folks who might just be in it for the perks. It sounds like we're wading into inheritance territory or something.
Not quite, although those situations can definitely involve third-party beneficiaries. It's a broader concept, anyone who reaps the benefits of a contract they didn't personally sign. Imagine this. You decide to be super generous and buy a car as a gift for someone.
Okay, generous friend, I like it.
You're the one signing all the paperwork with the dealer, right? But the car, the real prize of that agreement, that's going to someone else. They're the one cruising around enjoying that new car smell.
So it's not just about family matters, inheritances, those sorts of things. It's about any scenario where someone's getting the goodies, the intended outcome of a contract, even if they were never at the negotiating table.
Exactly. Legally speaking, a third-party beneficiary is someone who benefits from a contract they didn't personally strike. And here's where it gets interesting. If the original parties, the ones who actually hammered out that agreement, crafted it with the intention of this third party benefiting, that third party gains some serious leverage. They can actually sue if the contract goes belly up.
Hold on, really? So if I make a pact with a friend, hey, if this underdog team wins the championship, I'm buying you those concert tickets you've been wanting, and then I welch on the deal when they pull off the upset, my friend could actually take me to court.
Hypothetically, yes. If your friend was truly the intended beneficiary of that agreement, the one you were specifically aiming to please or reward, and you broke your end of the bargain, they might have legal grounds to sue.
Wow, that's wild. So it's not just about whose signature is on the dotted line, but whose benefit was at the heart of the deal, whose enjoyment, whose gain was the real motivating factor.
Exactly. It's about the intent behind the agreement.
Now, are all third-party beneficiaries created equal? Or are there different levels of involvement, different levels of legal standing?
You're spot on. There are two main categories. Intended beneficiaries, who have that right to sue we talked about, and then you have incidental beneficiaries. They don't have that same power.
Okay, let's break that down. Intended beneficiaries, those seem pretty straightforward. What are some classic examples?
Think of a life insurance policy. The policyholder, they make a deal with the insurance company, right? But the real recipient, the one who will ultimately benefit, is someone else entirely. That beneficiary, they weren't involved in setting up the policy, choosing the terms, but they are the whole point of it. And if the insurance company tries to dodge paying out, that beneficiary can sue to enforce those terms.
That makes sense. So what about the other side of the coin? Who are these incidental beneficiaries, and why don't they have that same legal muscle?
Incidental beneficiaries, they're the ones who might, just by happenstance, enjoy some positive side effect of a contract. Maybe their business sees a sudden boom because a big construction project popped up next door, bringing more foot traffic their way. They're benefiting, right? But they weren't the intended targets of that construction contract. It's a happy accident for them.
So it's all about whether their gain was a deliberate goal or just a happy accident, a side effect of the real deal.
Exactly. And courts have spent a lot of time dissecting these distinctions. There was a great case, Kmart Corp v. Balfour Beatty Inc. back in 1998 that really illustrates this. Kmart was all set to be a tenant in a new shopping mall under construction. They hadn't signed the construction contract itself, but the court said they were a clear intended beneficiary.
So even though they were one step removed from the actual construction agreement, they still had a stake in it.
Absolutely, because the whole point of that mall, the driving force behind that construction, was to house tenants like Kmart. Their needs, their presence were practically baked into the contract's very purpose.
So they weren't just a random store hoping to snag a lease once the building was up and running. They were integral to the whole endeavor.
Exactly. But here's where it gets even more fascinating. The court also decided that because Kmart was considered an intended beneficiary, they were bound by the rules of that construction contract, too. There was a clause in there that said any disputes had to be settled through arbitration, not a full-blown trial.
So they get a seat at the table, but they also have to play by the house rules. Talk about a double-edged sword.
Indeed. This case really highlights how, even if you're not a direct party to a contract, you need to be aware of its terms, how they might affect you, especially if you stand to benefit from that agreement.
Absolutely. Knowledge is power, especially in the legal world. Now, earlier you mentioned something really intriguing, that a third-party beneficiary's rights could be triggered even without them knowing about the agreement. How does that work? Seems a bit unfair, doesn't it?
It does sound strange, right? Almost like legal magic. It's called vesting, and it's a crucial, albeit sometimes head-scratching, concept in contract law. Essentially, it's the moment in time when a third party's rights, their stake in the agreement, become set in stone, legally enforceable. And sometimes this can happen even if they're totally oblivious.
That is wild. So you're telling me I could be entitled to benefits or even have legal obligations based on an agreement I didn't even know existed? It's like being secretly drafted into a legal team sport.
That's the thing about contracts. Their impact can ripple outward, sometimes in surprising ways. It really underscores just how crucial it is to be informed, to seek legal counsel, to understand your rights and potential liabilities, especially when you're dealing with agreements that go beyond a simple two-way street.
Absolutely. Being proactive is key.
Yeah,
Now, are there any other landmark cases that show how this vesting principle plays out in the real world?
definitely. One that always comes to mind is Hale v. Gross from 1987. It involved an attorney who was instructed by his client to include a specific gift in the client's will. Sadly, the attorney messed up and forgot. After the client passed away, the intended recipient of that gift, who had no clue about this promise, sued the attorney.
So the intended recipient, our third-party beneficiary, was completely outside the loop on that initial attorney-client agreement.
Yeah,
Yet they still had the right to sue.
precisely. The court's logic was that the recipient's rights, their entitlement to that gift, were vested, solidified the moment the attorney agreed to include it in the will, regardless of whether the recipient knew about it or not.
That's fascinating and a bit scary if you're an attorney who forgets to cross your T's and dot your I's. So even a spoken agreement, not even a formal signed contract, can have huge legal consequences for those indirectly involved.
Exactly, and it highlights that vesting isn't always tied to a specific document or signature. It's about when that promise, that intent to benefit, becomes legally binding.
That's a crucial distinction.
Yeah.
Now, do you have any other cases up your sleeve that demonstrate these third-party dynamics? Cases that might make our listeners want to brush up on their contract law?
Definitely. There's Zegas v. Superior Court from 1981. This one revolved around tenants in a federally funded housing project. The financing contract for the project included rent control rules, putting a cap on how much landlords could charge.
Okay, so the tenants themselves weren't directly involved in this financial agreement between the landlord and, say, the government or whoever was providing that funding, right?
Correct. But the court ruled that those tenants, they were intended third-party beneficiaries of that contract because those rent control measures, those were designed at their core to protect them. So when the landlord tried to hike up rents beyond the limits set in that financing agreement, the tenants had the right to sue, even though they hadn't personally signed that initial agreement.
Wow, so the tenants, even though they were absent from the negotiation table, had enforceable rights stemming from a contract they weren't a direct party to. It was like legal osmosis or something. They absorbed those benefits without even realizing it.
It's a great way to put it, and it shows just how far-reaching these agreements can be.
This has been an eye-opening deep dive into the world of contracts, third-party interests, intended and incidental beneficiaries who knew there were so many layers to these agreements. We've gone from lottery ticket analogies to construction disputes, and even touched on the power of a well-crafted or not so well-crafted, in some cases, will.
It's all connected.
It really is. And along the way, we've highlighted the critical importance of clear language in those agreements, understanding your rights, whether you're a direct party or not, and seeking expert legal advice when navigating these sometimes treacherous waters.
Couldn't have said it better myself. Awareness is key.
Absolutely. It's been a pleasure unraveling these legal complexities with you.
The pleasure was all mine. Always happy to geek out about contract law.
And to our listeners, remember, next time you encounter a contract, don't just skim the surface. Look beyond the primary players, those big, bold signatures. Ask yourselves, who else might be impacted, even indirectly? You never know, it could be you. Keep those legal minds sharp, everyone. Until next time.